Thank you very much indeed for that sweet, kind introduction. And hello, Dublin. It's really good to be with you live, even if it is at a distance. I'm sitting comfortably in my study at home in Yorkshire, rather than in your great university. I've long had a soft spot for Ireland and the Irish, and particularly for Dublin. After all, you had a woman Chief Justice of your Supreme Court long before we did in the UK. And as some of you may know, I have two wonderful Irish grandchildren who live just down the road in Glenageary, and would be spending the weekend with them if it weren't for the pandemic restrictions on both sides of the Irish Sea. Because of those restrictions, your experience as students must be so different from the usual student experience. At least you have the advantage that you are the tech-savvy generation. You can do your research online. You can write your essays and examinations online. You can go to lectures and seminars online. My generation envies you these skills. We have had to learn how to do some of these things. Most of us have never heard of Zoom until last March, but it isn't the same as face-to-face contact with your fellow students and the academic staff. And your surroundings may not have been as helpful as they would have been in normal circumstances. So many, many congratulations on keeping going and trying to make things as normal as they possibly can be, like this meeting. None of us could have foreseen the chaos which the pandemic would bring to our lives. So if there's one thing that COVID-19 has taught us, it is that we must expect the unexpected and do our best to prepare for it in advance. And a university degree, whatever your subject, is just such a preparation. It gives you the skills you need to be able to turn your hand to whatever comes your way. The skills of thinking for yourself, of finding things out for yourself, of working hard, well, at least when you have to. And it gives you the courage in the face of adversity and the resilience to pick yourself up if things have not been going your way. I also think that a university gives you the values you need to lead a happy and successful life. A thirst to discover the truth, the fair-minded evaluation of evidence and arguments, and above all, a respect for the equal dignity of all people, whatever their religion, their ethnicity, their gender, or their background. University is a great place, or ought to be a great place, for meeting all kinds of people, and I hope that you're still able to do this despite it all, and even have some fun as well. In the meantime, my generation owes a huge debt of gratitude to your generation for putting up with these extraordinary interferences in your lives, basically for the sake of the oldies and others who are likely to suffer more than you if they catch the dreaded virus. My impression is that the Irish have been rather more efficient in responding to the virus than we have been in the UK, which is another reason for admiring you all. So thank you so much for honouring me in this way. I do truly regard it as an honour, a real privilege. And I look forward to answering any questions which you may have for me. Thank you.
Thank you so much. And you touched on something that I was actually wanted to ask you about first, which is obviously COVID and how COVID is shaping all of our lives in unimaginable kind of ways. And something you've been a strong advocate for is the rule of law throughout your career. And obviously in our current situation right now across the common law world, as we deal with these various regulations and statutory instruments designed to prevent the spread of COVID, people are now very concerned in a very immediate sense about the rule of law, specifically about the need for laws with such large scopes to have clarity, certainty, and consistency. Do you think that COVID is going to have long-term impacts on how people engage with and understand the rule of law? And what do you think those impacts might be?
Well, it's difficult to predict, isn't it, as a result of COVID? So let us not be too foolhardy. One of the things that we have been very concerned about in the UK, and I expect it's similar but not the same here in Ireland, is that the government, our government, has produced regulations with breathtaking rapidity and virtually no parliamentary scrutiny of them. They've got a bit better in more recent times, but when they first started, the first lockdown that we had last March was introduced with no parliamentary scrutiny for several weeks of the regulations that introduced such draconian interferences with our everyday lives. As I say, it's got a bit better, but not much. It's still basically Parliament playing catch up. And of course, it means the courts are also playing catch up, because if the courts want to review whether the regulations are valid, intra vares the powers that Parliament has given to the government, again, it's playing catch up because the regulations will have changed by the time the case gets to court. So these are very worrying implications for the rule of law. And fortunately, the House of Lords Constitution Committee is very alive to the fact that we could be doing things better. As I say, my impression, and you'll tell me if I'm wrong about this, is that in Ireland, you straight away had a framework of 5 stages of response, and everybody knew what was in those 5 stages, or maybe they didn't, but maybe it was not too difficult to find out, and you knew which stage you were in. Well, we didn't do that. We only got onto the idea of having tiers, but these were geographical tiers that affected different parts of the country. We didn't have a framework, and so all those months from March to June during the first lockdown, or March to the beginning of July, they could have worked out a framework like the one that you have, but they didn't. And I think that was an opportunity wasted because it could have been scrutinised. Parliament could have discussed it properly, and that was an opportunity missed. So I hope that lessons have been learned, that you can respond to emergencies in a better way than, I should say England really, because Wales and Northern Ireland and Scotland are different entities for this purpose. And so I should only really talk about England. But that's what I think the lessons are, and very important ones they are too. There is a further one, sorry, and that is, and I don't know whether this is also true in Ireland, there's a great confusion between the regulations, which are the law, which say what you can and cannot do, what is and is not a criminal offence if you do it, and the guidance which the government gives as to what those regulations mean and how they should be applied. It's very fuzzy, and I'm quite sure that most people don't know what's in the regulations and what's simply guidance. An example in the early days was that they said you could have one period of 1 hour's exercise a day. That was a reason to leave the house. That isn't what it said in the regulations. It didn't say one period and it didn't say 1 hour. That was just the guidance. This is what we'd like you to do. And there are many similar examples, even under our much more detailed current regulations.
Those kind of things definitely are really relevant, particularly the difference between sort of legislation and guidelines. And in Ireland too, there's been a lot of sort of attempted constitutional challenges on that basis. But something that you mentioned there that I'd like to ask you about is about parliamentary sovereignty and how that can be checked and reined in. And the most important, I suppose, constitutional principle, as I understand it, of the United Kingdom is that of parliamentary sovereignty. But it is also quite unusual in a European constitutional context. So in theory, Parliament could decide to pass a law with very large scopes, as it has done in recent times, doing away with certain fundamental rights and things that we take for granted and things that people are used to. And there would not necessarily be a lot that the court could do about this. Do you think that the court, and the Supreme Court specifically, is a significant enough check on the other branches of government, given that it is limited by this principle?
Well, we are so used to the principle of the sovereignty of Parliament in the UK that I don't think it's under any sort of a threat. On the whole, Parliament does not legislate to interfere with fundamental rights and freedoms. The interferences that we've had with the COVID have been in regulations. Now, they have been eventually approved by Parliament, but the regulations are made by the government. And in those circumstances, of course, they're made under particular legislative powers, which Parliament has given to the government. And the courts do have a role in deciding whether or not the regulations are within those powers. And there are 2 possible ways in which they can be challenged. One is that most of the regulations that we've had have been made under public health legislation. And there is a view that the public health legislation was all about controlling the activities of people who were or might be infectious, and not about controlling the activities of healthy people. And yet the regulations are all about controlling the activities of healthy people. Now, that was an argument that was made in our Court of Appeal and failed. I don't know whether it's going to the Supreme Court or not, and I have no idea what would happen in the Supreme Court. But I do know at least one former Supreme Court justice who thinks that the regulations are all ultra vires, which is a lovely thought, isn't it? Of course, the other way in which they could be ultra vires is if they do not comply with the convention rights, because the regulations must be compatible with the convention rights. And obviously there are arguments at the margins. If it's a qualified convention right, one that can be restricted, if it's a proportionate way of achieving a legitimate aim, well, then that's a matter of judgment, and maybe the gross interference with our private lives and our family lives is justified for the greater good of the greater number, trying to get the epidemic under control. But if you've got unqualified rights, the ones that are absolute, and there isn't a balancing act, well then some of the things that have happened under the regulations, or indeed have happened by the acts of public authorities in the UK, are very arguably breaches of Article 3. That's the no inhuman or degrading punishment or treatment, because the way in which people have been kept in prisons and other secure institutions, possibly in care homes, over the past few months could, in my view, well meet the high threshold for being contrary to Article 3, in which case there is no defence to that and shouldn't be allowed. So I do actually think that human rights are a good framework for looking at the justification for responses to emergencies, including the pandemic.
Absolutely. I think you touched on something really interesting there about how the task of interpreting the UK Constitution is always in terms of compatibility with the Convention too, and that those things are still quite strong. But despite the existence of the Convention, sorry, the task of interpreting the UK Constitution is still quite an unusual one, in that the Constitution itself is unwritten. And other judges across Europe and indeed across the sort of common law world have clearer roles, since they don't solely have these unwritten principles to guide them, but they have those principles to guide them in addition to fixed constitutional articles with fixed wording that they know is not going to change. Do you think that it's time for the UK to introduce a written constitution? And how do you think that your experience as a constitutional judge was different to your international peers because of this sort of unusual feature of the British legal system?
It is an unusual feature. There are apparently only 4 countries, at least in the developed world, that don't have a written constitution. And they are the UK, New Zealand, Israel, and the Isle of Man. I was taken to task by saying there were only 3 because I had forgotten the Isle of Man, and the Isle of Man took me to task about that. Yes, it is an unusual situation, but written constitutions do not solve all problems. Some of the most difficult cases that we had in the UK Supreme Court were the ones about the machinery for leaving the European Union. And a written constitution would not have solved that difficult demarcation dispute between what's a matter for Parliament and what's a matter for the government. That would not have been solved, I think, by any written constitution that I have seen. And I've seen quite a lot of them in the course of my judging career. The other thing, of course, about having a written constitution is that it does put an awful lot of power in the hands of the judges. And that's true in Ireland, but it's even more true in the United States of America. And I'm not sure that the judges in the UK want that power. I don't think we really want to be able to invalidate acts of Parliament or provisions in acts of Parliament, unless Parliament has told us that we can, which it did with European Union law, but it's now repealed the European Communities Act, so we no longer have that power. And we don't have that power under the Human Rights Act. We can't invalidate acts of the UK Parliament. And I would say, I don't think any of us wanted to. I think we think our job is difficult enough without having that additional burden, which would bring us much more into the political arena, where we don't really want to be. But of course, the final thing to say about a written constitution is it's not going to happen, is it? I mean, the written constitutions that there are in the world have generally come about when and because a former colony or part of an empire has either been given its independence or has forcibly taken its independence, as happened with the United States. You know, they cut themselves off from, it was Great Britain. I think it didn't become the United Kingdom until Ireland was part of it, and that was obviously a little bit after the American Revolution. But they decided that they had better have a constitution for this new country that they were putting together. And then every country that's got its independence from the British Empire has been given a constitution by the Brits, which they have then domesticated and revised and usually kept much the same basic structure. So we've never had that situation. We've never had a situation, at least in modernish times, you know, not since we got rid of the Romans, I think, can we really say we've had that situation.
And I can't see England declaring independence from England anytime soon, so that it makes sense.
No, I think not. No, I can see Scotland declaring independence.
I don't make mine on England.
Yeah.
I think something interesting about that is that obviously you have the common law, then it becomes much more important. Obviously it's important in all common law countries, but to guide you when you have these very difficult things that even a written constitution wouldn't solve, that you kind of mesh these things together to try and come to an understanding. And that kind of lives on long after the judges who initially made those judgments have left the court. And you obviously have an important legacy as the first woman to be president of the Supreme Court, but you have another legacy too, which is those judgments. And you're obviously particularly well known for your judgment in the prorogation case, which was read with approval all over the common law world and will definitely go down in history. But I'm wondering how you feel about your legacy as a judge and what judgments of yours are you most proud of?
Well, obviously I have to be proud of the achievement of the whole Supreme Court in the prorogation case, because it was a unanimous judgment and it was genuinely unanimous. Everybody had put in their thoughts and agreed on the outcome and agreed the judgment that Lord Reid and I wrote. So that in itself is something to be proud of, I think, quite irrespective of the content of that judgment. There are all sorts of judgments of which I'm quite proud. There was one where we said that the word violence, particularly domestic violence, was not limited to physical violence, you know, hitting or threatening to hit, and could include what we now call coercive control, you know, other sorts of abuse which dominate, by one person dominates the other person. I'm quite proud of that one. I was quite proud of a judgment in which we said that the best interests of the children involved had to be a primary, not necessarily the primary, but a primary consideration when deciding on immigration matters in relation to their parents. So the children shouldn't necessarily be obliged to leave just because their mother, in that particular case, shouldn't be in the United Kingdom. If she had to go, that would mean the children who were British citizens would be uprooted from their homes, their schools, their friends, the whole familiar way of life, and have to make a life in a completely different place with which they had no connection, clearly not in their best interests. That principle, which comes from the United Nations Convention on the Rights of the Child, has been applied to a lot of other public authority decision-making as well. So those are two Supreme Court judgments that I'm pleased with.
and those are ones that we could learn well from in Ireland. I think we are only kind of catching up to you with the coercive control. We only recently had our first conviction for that, and so that's something that's definitely worth being proud of, and having that sort of influence. And you kind of, those cases in particular are quite sort of progressive ones, and you across your life have had an amazing career where you've had to break through a rather significant glass ceiling, and you've been outspoken about how people from non-traditional backgrounds has to be encouraged to practice law. And I'd share your view that since the law is meant to be all about equality and fairness, it makes sense that the judiciary should embody those values and have experience with these things. But you've also been realistic about how difficult it can be for everyone, particularly minorities, at the bar. And how have you seen the culture at the bar change across your lifetime? And are you hopeful for a more diverse future?
It's definitely changed quite dramatically over my professional lifetime. But as you know, I'm really quite old, I'm 76. And as you said, I was called to the bar in 1969. So that's quite a long time ago. And many things are noticeable. When I was called to the bar, there were far fewer women than there now are. It's roughly half and half, men and women being called to the bar. Of course, the proportions change with seniority, and that's mainly because of attrition, which we could talk about. It's a problem in all professions, but it's a particular problem in the self-employed legal practitioners, both barristers and solicitors. It's a problem. When I was called to the bar, there were, of course, a lot of people from ethnic minorities being called to the bar at the same time. Probably the majority of people in the room, now I come to think about it. But the reason for that was that many of them came from Commonwealth countries where being called to the bar in England was a passport to practicing in their home countries. Now that is now not the case. I think only in Malaysia, I think we still have a lot of Malaysian students and we have a lot of Cypriot students, but otherwise being called to the English bar doesn't give you any particular advantage back home. So why come and spend all the money that the bar course now costs? But we do have quite a high proportion of people from Black and ethnic minority backgrounds who are now being called to the bar. That it's quite a visible, sizable proportion. Again, we don't have so many higher up, and that is a problem which needs to be tackled. And people are aware of it as a problem. So that's a good thing. People are aware of it as a problem. The profession wants to be as diverse as it possibly can be, recognizes the value of diversity. And so people are trying to tackle it. But one of the big obstacles to tackling it is the cost of qualifying for the bar. When I qualified for the bar, the exams were very easy, and I was able to swat for them using a self-tuition correspondence course that I had bought from the College of Law for some trivial sum now. It didn't feel trivial at the time, but it would be trivial now. And I spent 8 weeks or so swatting in my garret and passed the exams with flying colours. Now you have to do a course, well, you can do it part-time over 2 years or a full-time course that takes the better part of a year, and it's very expensive. And I don't know how it is in Ireland, but it certainly is a deterrent to people who, having already had to incur a lot of expense to get a university degree, are then thinking of going on to qualify as barristers, with all the uncertainties that a career at the bar brings with it in any event. So I'm hoping that we don't go backwards from the advances that we made over most of my professional career.
Absolutely. I think that's something really interesting because we talk a lot, and it's important to care about more women and more people from minority ethnic backgrounds practicing at the bar, but something that I do think gets neglected is sort of the cost of it. So I'm glad you brought it up. And it is the similar in Ireland, where it's hugely financially inaccessible, and for that reason it's becoming less and less popular through the years as it becomes more and more expensive and less feasible to people. I think I wonder sort of in light of that, how do you think minorities can best be encouraged in the legal field? Because it's well documented that people from minority groups, whether it be women, religious minorities, or ethnic minorities, tend to feel more unqualified than their more privileged peers, even if that is not actually the case. Is this kind of self-doubt or imposter syndrome common in the British legal sector in your experience? And if so, how do you think it can be dealt with?
Well, yes, I think I certainly confess to having felt an imposter at various junctures in my life. You know, when I was starting something new and wondering about whether I could cope with it. I don't think it's uncommon. There may be privileged young men with a sense of entitlement. I certainly encountered lots of those when I was at university. I don't know what it's like in Trinity, but there was certainly in Cambridge, there were a lot of those young men who'd gone to a school which led them to believe that they could rule the world, basically. And then they went to a university that did nothing to dent those assumptions. Now, they may have been churning over with self-doubt inside, but it was not apparent, and I don't think a lot of them felt it. Whereas I don't think the women ever felt quite as entitled, because we hadn't traditionally been entitled. And I think when I went up to Cambridge, I felt enormously privileged to have that amazing education that was denied to so many women, rather than feeling that I was entitled to that education, or even that it entitled me to rule the world. I didn't. I think I rather upped my sights as to what I was going to do as a result of being amongst all those entitled young men, but it's not something that I started out with. And I think that is life. And you have to recognize that, yes, maybe you do feel that doubtful about whether you can do something, but then think about it and look at the other people who are doing it. That's a big tip. If you look at some of the other people who are doing it, and you think, well, I could do that, so why don't I give it a go? When I was starting out at the bar, there were really quite a lot of mediocre barristers, and quite a few judges who got away with behaviour that they would not get away with these days, because people are now much more thoughtful about how judges should behave, frankly, and that's a very good thing. And so it didn't take a lot to look at them and think, well, if they can do it, I think I can probably do it too. So best corrective.
Yeah, exactly. And it's not just the bar that's challenging. It's not just being a practitioner that's challenging, but all judges, particularly female judges across the world, tend to be subject to a lot of media vitriol and political bashing. And I think more so because of their gender. I think in your valedictory remarks to the Supreme Court upon your retirement, you went through a few of the assumptions that have been made about you and your work throughout your legal career, for instance, being called too ideological and hell-bent on destroying the institution of marriage, despite all of the evidence to the contrary. Are you concerned with how the media reports on judges in this way? And do you think that it has any impact on how people view the judiciary as a whole?
Well, of course, that's not a problem that's unique to women. The worst example that we had in the UK of that was with the first Brexit case, when the Lord Chief Justice, the Master of the Rolls, was second in command in England and Wales, and another very senior judge who found against the government at first instance, were branded enemies of the people by a very, very popular, much read newspaper, which was scandalous. They really shouldn't have done that, but they'd every right to do it if they want to do that sort of thing. But the problem is that they are then risking bringing the judiciary into disrepute, and therefore the rule of law into disrepute, and that's surely not what they want to do. Perfectly okay to criticize a decision in a reasoned way, but not to call people enemies of the people when all they are doing is trying to decide a difficult case according to law. And of course, there was always the Supreme Court to put them right if they were wrong. But of course, they weren't wrong. They were right. The Supreme Court agreed with them. And the newspaper was much more moderate in its comments on what the Supreme Court did. I think in a way that episode did mean that a few lessons were learnt.
Yeah, absolutely. We have to kind of take them as cautionary tales, because I suppose when you look across the sea at the United States, where how Trump supporters immediately turned on the courts when they weren't doing things the way that they liked, and it meant that they are come to take the belief in mind that the courts must be corrupt because they don't align with their political views, and the people who are in those courts must be removed or dealt with, and those kind of things. So it can be quite dangerous if it isn't dealt with. So it's I think it's best to be kind of pragmatic and to learn from it as it goes on, and hopefully that those kind of episodes don't reoccur too much in Europe. I suppose something that I want to ask before I open questions up to the audience, I see we've already gotten a few in, but just a simple and a straightforward one, just for the law students watching, and as a law student myself, I have to ask, what advice or what hopes, if any, do you have for us?
Oh, hopes for you. I hope that you have long and happy careers doing what you like doing in the law. And I think that my advice is always the same. Enjoy what you're doing. Because if you don't enjoy it, you won't work hard at it. And if you don't work hard at it, you won't do well at it. You know, as a law student, the law is pretty hard work. We always used to think that, yeah, the medics work the hardest, the scientists the next hardest, scientists and engineers the next hardest, and then the lawyers. And the other arts and humanities people did not work as hard as we did. But it is necessary to enjoy it, because there's nothing worse than having to work hard at something that you loathe. And it does tend to mean that on the whole, you won't be very good at it. So that's my advice to you. Enjoy.
I think it's straightforward and easy advice to take on, which is good. I think the first question that we had was from somebody who was asking about the experiences of Black barristers in the UK being stopped when entering courtrooms and treated as a suspect in criminal trial, and what can be done to kind of rectify the assumptions that are clearly being made about those barristers.
Well, I only know of one very well publicised case of a young Black woman barrister who was, I think, 3 times in the same court building mistaken for the defendant rather than a barrister. Now, that is terrible. That's a dreadful thing. It was a good thing that it got a lot of publicity, and she has written about it. She's very articulate. Well, most barristers are pretty articulate, and she's very articulate. And that's a very good thing, because it will have, one hopes, caused some people to think, oh, is there a need for some training in unconscious bias here? Now, to some people, training in unconscious bias is anathema. That's because they don't think that they've got any unconscious biases. We've all got unconscious biases, all of us. The problem is that you do, because they're unconscious, you do have to have techniques for asking yourself, am I letting my hidden assumptions guide my thinking in this situation when I shouldn't be doing? And that was a very, very good example of somebody's thinking of which they wouldn't be aware. They would just think, yes, it's more likely that a Black person will be the defendant than a barrister. Well, that's not a good enough reason for assuming that somebody's the defendant. It's just rude and thoughtless, and we ought to be taking steps to change it. I actually think the court service probably is, but they've got a lot on their plate at the moment.
Absolutely. I think the language around these things is really important as well, because once you have those kind of unconscious bias training, you can understand those kind of things. And in the next question that's come in is from Ben Conlon, and he asks, I suppose in relation to language and inflammatory language, is it shocking or concerning to see the government making similar comments to the newspapers that you referenced in recent years, such as Priti Patel referring to activists and lefty lawyers and sort of painting it out to be something to be worried about?
No, I think that's very, very unfortunate, because the government depends upon the justice system actually as much as anybody does. Okay, some criticisms are valid, but there's nothing valid about criticizing people for doing their job, which is representing their clients to the best of their ability. And in the case of judges, deciding cases to the best of their ability. We don't, of course, always get things right. I don't suppose legal practitioners always get things right. And there may be some who are not as principled as they should be about how they conduct cases. I think people I respect have voiced that view about certain legal practitioners, and that's in which case the profession ought to be sorting them out. And the judges, of course, should also be sorting them out to the extent that they're deciding cases. But it's not a good idea for the government to be casting doubt on the bona fides of the justice system and the legal profession in that way.
Yeah, absolutely. And it's definitely concerning in terms of how people will then perceive those comments, people who might not have interacted with the law, and how they'll perceive the law and how they'll perceive their own chances if they do ever need to go to court. So it's definitely does need to be addressed. Another question we have here from Lauren Pryor, who says, thank you so much for taking the time to speak at Trinity. I'm glad you mentioned the expansion of the definition of violence and the introduction of the criminal offence of coercive control. Although the offence is still relatively new, I was wondering whether you had any thoughts on how this area will develop in the future.
I haven't got anything very constructive to say about that because it is early days. We decided the question in the context of housing. It was a young mother who had left her husband because he was controlling her in that way, and she was very frightened of him. But because he hadn't actually hit her, the housing department was regarding her as intentionally homeless and refusing to rehouse her. And we said, no, this was a situation in which she couldn't reasonably be expected to go on living with him, and they had a duty to rehouse her. That sort of context is as important as a criminal context. But obviously there are some cases where it reaches such a pitch that it deserves criminal penalties. And but it isn't, because it's vaguer than hitting, isn't it?
It's harder to define, definitely.
It's harder to define, and it involves value judgments. When is somebody actually being controlled? When does respect tip over into fear and fear of harm, unless you do as you're told to do by the person who's abusing you? These are quite fine judgments, and so I would not expect it to be easy to decide whether or not to prosecute or even to decide whether or not to convict. But I'm still glad that it is recognised as a crime, because there's no doubt that it can be even more damaging than physical violence. I don't know if any of you know the radio soap opera called The Archers.
I don't, but I'm excited to hear about it.
Well, it is a radio drama. It's a soap opera. It's on 4 nights a week at the moment. It used to be on 6 nights a week for a quarter of an hour. And for a whole year, it developed a story of a man who was abusing his partner. And we could all hear, because we were eavesdropping, so to speak, on their private life. But bit by bit, he completely took away her sense of self-worth. He made her give up her job. He cut her off from her family and friends. He stopped her driving. He deprived her of her mobile phone. He made her think that she was going mad. He made her pregnant when she didn't want to be pregnant. Bit by bit, he completely destroyed her sense of self-esteem and agency. And we could see it happening. And I was very glad about that, because it was a perfect example of coercive control, which the great British public probably hadn't known much about until the Archer's listeners heard that happening over the space of a year. And it escalated to such an extent that she basically stabbed him. He was goading her into stabbing him. And this was her defense, that he had basically driven her to it. So we had another drama with the criminal justice system over the next year, which resulted in a triumphant acquittal. So it was a very good educational experience for the great British public.
Which is really great, because I think things like coercive control, because they're new terms, people who haven't had much direct experience with it, or who don't know people who've had that kind of experience, need to see that both in the courts and just more informally in the media and in things like this. Because I think it's great when you have a judiciary that has people from more diverse backgrounds on it, who may have experienced that firsthand and are going to be more delicate in interpreting it, because like you say, there is still challenges ahead in defining what the thresholds for that will be. And obviously the law likes to have there to be rules and ways of, and criteria for determining if something is or isn't. But it'll be interesting to see how that develops now that people recognize that it is so important, and there is more people on the judiciary who have the background necessary to kind of understand it. We have another question in here from Amy Cox, who asks if she can ask you about the recent decision in various claimants versus Barclays Bank. Many of us first year students have been studying vicarious liability and tort law recently, and she would like to ask about what you believe the significance of this judgment is to tort law.
Yes. Well, that's quite a technical question if quite a few of the people here are not lawyers. But, and I think that's true, isn't it? You're not all lawyers, are you?
No, all sorts of backgrounds, but a lot of lawyers here.
Right. So we have a principle in the common law. It applies in Ireland as well as in the UK, which is that in certain circumstances, an employer is responsible for the wrongs committed by an employee in the course of the employee's employment. That's the traditional way of putting it. So there are two questions. Firstly, is this person an employee? And secondly, was what that person did in the course of their employment? The Barclays Bank case was about the first of those questions, because we draw a distinction in the law between somebody who is an employee, which is basically working for somebody else's enterprise, and a person who is self-employed, who is basically working for his own enterprise. Does that make sense?
Yeah.
That is the basic distinction. We've gone beyond pure employment into other people who are very like employees, which is what caused the problem in this case. But this was a doctor. He was a general practitioner. He had a variety of roles. He had some roles did some sessions in hospitals. He worked for a variety of clients, and he had a variety of patients. He had his own premises, and from time to time, Barclays Bank asked him to do medical reports on people whom they were thinking or going to offer jobs to. And a lot of these were young women aged about 15, 16 at the start of their employment careers. And he abused them. He abused a lot of them. And the question was he self-employed, or was he akin to employed by Barclays Bank? And we held that he was working for himself, for his own business, which was this portfolio of medical jobs that he had, and that he wasn't an employee or akin to an employee of Barclays Bank. If he had been held to be an employee or akin to an employee, it's very difficult to think of any circumstances in which anyone gets somebody else to do a job. who wouldn't be responsible for any harm that they caused in the course of doing that job. So the central heating engineer who's been in my house trying to sort out my central heating, well, clearly another enterprise, not my enterprise. I'm the customer. But it would be very, very difficult to draw that distinction if we had held that the Barclays Bank was responsible for him. So yes, it's quite an important decision in an area which most people probably don't have to think about.
But still important, I think, because it does still sort of affect us, whether we know it or not, and particularly as nature of employment is changing and so many people are in the gig economy, it's important to kind of have those distinctions between who works for who. Another interesting question we have in from Sal, who asks, he says, thanks so much for speaking to us. While this has nothing to do with the law, or maybe it does, when did your journey with Brooches begin? I think somebody called them, Lord Reed, I think called them like a swashbuckling symbol of womanhood or something like that.
Yes, no, a symbol of swashbuckling womanhood, I think is what he said. Yes, that's right, which is a lovely phrase. I like it. Well, the Brooches really began when I first started sitting in the family division of the High Court. Now, in family, possibly in family cases in county courts as well, but in family cases, we don't wear robes in court because we're sitting in private. Though now the press are allowed in, but in those days they weren't. So we tend to wear dark suits. I hate dark suits. As soon as I could get into something different, I did get into something different. I much prefer dresses. But anyway, so I was wearing these dark suits and my husband started giving me brooches to brighten them up. Just a little bit of light relief amongst the somber tones. And he started with a spider, as it happens. It was an antique silver spider, which I still have. And then he went on, of course, once he got the idea, he went on with it. And then other people got the idea too. And so most of my brooches are creatures of one sort or another. I've got several spiders. I've got one on today, just a little one. I've also got dragonflies, butterflies, creepy crawlies. I think I've got a cat, and I think I've got a fox, and I think I've got, so quite a lot of creatures. And what happens is that they tend to find their way, they have a mind of their own, these brooches. They find their way onto a particular garment, and that's where they stay, basically. So the choice of garment dictates the choice of brooch.
Absolutely. And it's great to have somebody change the robes and bring it into the future a little bit, and do something a bit different with it, which is great. Another question we have, more sort of legal, I suppose, in nature. Who is a judge or jurist that you looked up to as a student or as a young barrister or judge?
Right. As a student, I suppose all law students looked up to Lord Denning when I was a student. Didn't always agree with him, especially he had very old-fashioned ideas about women, in fact, if you read some of his judgments. But we did look up to him as somebody who was prepared to do what the common law does best, which is build on existing principles and develop them to meet new situations. That's what the common law is supposed to do, and that's what he did. Some people thought he went too far on occasions, but an awful lot of what he did stood the test of time. Always, if the House of Lords disagreed with him, well, then was put right by Parliament in the direction that he wanted. So I suppose he probably does account as the hero figure. But there were some very good teachers in Cambridge, very inspirational, brilliant minds from whom you could learn a great deal, and also aspire to try that kind of legal thinking. So I won't name names because they won't mean anything to you, but they were definitely people that it was good to have encountered. When I went to the bar, this was in the north of England, and of course our great heroine there was Rose Heilbronn. She's one of the first two women to take silk, become QCs, well, it was KC it was then, in 1949. She had an enormous practice, a lot of it in criminal cases, some of it in personal injury cases, well known for defending murderers, and was in the newspapers very, very frequently. During the 50s, she was extremely famous. She eventually became a High Court judge in 1974, but she had had to battle a great deal of misogyny in her time, despite her many talents. So she was an inspiring figure for the rest of us on the Northern Circuit. And then when I became a judge, certainly when I became a judge in the appeal court and therefore was dealing with all sorts of law, not just family law, Lord Bingham was a hero to all of us. He was successively Master of the Rolls, then Lord Chief Justice of England and Wales, and then became Senior Law Lord. And as Senior Law Lord, he led us through the early days of the Human Rights Act. And he was a brilliant judge and a very, very decent person as well. So, yes.
So all through stages, yeah, definitely. I think it's interesting now that you, at the end of your career now, will be one of those people for the up and coming generation, I suppose, as having broken through as many glass ceilings that you had to in your career. So that will be the same for yourself, and also in terms of your judgments, that are in the same way that Dennings, you can't really ignore them. You'll find them across a number of different things. I think there might be time for about 2 more questions, and then we can wrap up. I think something interesting we have here from Saoirse, who asks, has your passion or determination ever been mistaken or remarked as pushy or interfering? As a woman working in a predominantly male field, how have you dealt with situations like this, and how have you had to alter your delivery of ideas by taking a more submissive and subtle approach?
That's a very, very good question. I have a horrible feeling that subtlety is not my way. I don't really see why we should have to behave any differently from the way in which the men behave.
Absolutely.
We're either going to win the argument or we're not going to win the argument. It's either a good idea or it's not a good idea. So I am aware that some people have found me troublesome. I didn't really know that until one of my former colleagues amongst the law lords published his diaries.
What a way to find out.
Unbeknownst to all of us, he was keeping diaries. Throughout his life, he was keeping diaries and decided to publish them. His remark about me when I was about to join the law lords was that Brenda will be a source of some anxiety until we have got used to the very different contribution she will make. So he saw me as different. He saw me as anxiety-provokingly different, whereas I didn't see myself as different at all. I saw myself as a woman, obviously, and women are different from men, but I saw myself as behaving in much the same way that the men around me were behaving, just as irritatingly pushy or as arrogantly assertive as they.
Absolutely, and for the best way, especially in a tough career, it's important to be ruthless and to be these things, and not to think that because of the way we've been socialized of our gender that those things are bad to be. I think our last question is something that I find interesting. Nisha Curtis asks, in your career, what has been the most significant impact technology has had in the development of the law? And I know the Supreme Court was the first to really have sort of cameras in and have those kind of proceedings be very open. So what do you think the most significant impact that kind of technology has had?
Well, I think televising the proceedings in the Supreme Court has undoubtedly had an impact. People are not going to watch very frequently, but if it's a very high profile case in which there is a lot of interest, people do watch. Millions of people watch. And this is good because although the proceedings are really boring, it gives some idea about what the problem is, what the issue is, what we're arguing about, why it's difficult, and an idea that we are listening carefully to the arguments on all sides of the question, and then we're doing our best to work out what the answer is in a principled way. We're not just making it up off the top of our heads as we go along. All of these things you can see, you can watch them in action. And so although it is on the whole pretty tedious, it's not like a drama, it's not like a courtroom drama in the television sense. Nevertheless, it has a huge educational impact, I think. It's been a very good thing. Does your Supreme Court televise?
I think we've had one or two, but as far as I know, it's not a regular occurrence.
It's much better if it's regular, because then you just don't think about it. You know, the cameras are there in the courtroom, they're up in the corners, we're not conscious of them, and I don't think the barristers are conscious of them either, and so we don't often have barristers playing to the gallery. I can only think of one recent example. Generally speaking, they get on with the job just as everybody else is getting on with the job.
Exactly, and plus it makes people feel more connected to the judiciary, which is the most important thing, that they feel like they're being served and that they're being looked after, and their interests are being looked after, even if they don't think that it's the most thrilling thing they've ever watched. It's still important to have. So definitely. But yeah, I suppose I think that's time for all the questions that we have, and there's a few more, but I don't think we'll have time to get through all of them today, because we'll be here forever. So I just want to thank you so much for coming and speaking to us today. Can't wait for you to get your medal in the post soon. But it's been an absolute honor to have you here with us and to number you among some of our other honorary patrons and our other judges throughout the years. So thank you so much for speaking to us today.
Well, thank you. As I said before, thank you so much for inviting me and giving me your medal, which I really do look forward to getting in the flesh. And I do hope that it won't be too long before I can actually visit Trinity again in person, because I have a soft spot for you all.
Absolutely. I'll be looking forward to having you here. Thank you so much. And thank you so much to everyone for watching this afternoon. We've got a few messages coming in saying thank you again. But thank you so much, everyone, and enjoy the rest of your afternoon. Stay safe in the meantime. Bye.
Bye-bye then. Bye-bye.